very good evening to all of you friends. A very warm and a hearty welcome to all of you friends on behalf of everyone here at BYJU'S Exam Prep. Now, BYJU'S Exam Prep brings to you the top 20 legal judgments, part 5. Now, in the previous session, we have discussed with you certain very important judgments. Similarly, in today's session, I'm going to discuss with you certain very important judgment relating to certain very important aspect relating to service law, relating to others. Now, why are we having this session? We are having this session with a view to inform every student what a student must be aware of insofar as his preparation for CLAT 2023 is concerned. Now, CLAT 2023, which is going to happen in this year itself, in the month of December, 18th December. You will be getting certain questions, certain passages based on legal development. Now, legal development includes certain important knowledge about recent development in the courts. Now, what has the courts decided in the last few weeks? Okay, so we bring to you this very important session, which is going to help you out insofar as your preparation to this law entrance is concerned. So without much ado, let's begin. Now, before I begin, BYJU'S Exam Prep brings to you the All India Mega Mock for CLAT 2023. Now, if you are preparing for CLAT 2023, do sit for this All India Mega Mock, which will give you a real CLAT experience. How will CLAT look like? By giving this particular mock test, you get to understand your strength, your weakness, and you can also identify the best CLAT strategy for yourself. So why delay or why late? Sit for this exam. This is an All India Mega Mock. Now, this examination is live and its tenure is till October the 2nd. So I request each and every one of you watching me live to definitely sit for the All India Mega Mock CLAT 2023. Now, what is the agenda for today's session? We are going to discuss Anuj Garg. Then we are going to discuss Uddhav Thackeray Group judgment by Justice D.Y. Chandrachud was heading this 5-judge bench. So what all has happened? Okay. Now, apart from Anuj Garg, we are going to also discuss with you Madan Mohan Rao, as well as Jagdish Prasad Sani versus State of Rajasthan. So these are the 4 very important judgments that we are going to discuss with you in the course of this session. Now, so let's get started. The first one, Anuj Garg versus Deepak Kumar Garg. Now, a father must provide means to maintain his wife and minor child. Now, suppose there is a child, there is a wife. It is the duty of the husband. It is the duty of the husband to earn by legitimate means to maintain his wife and his minor child. That is what the Supreme Court in Anuj Garg has decided. The Supreme Court has said that the husband is required to earn money even by physical labor if he is unable to and could not avoid his obligation. So every person, every father has a duty, has a responsibility to provide, to means and maintain his wife as well as the minor child. Now, this happens to be a very important judgment. That means a father cannot shrug away his responsibility insofar as maintaining his wife and minor child is concerned. So this happens to be a very important judgment. Now, the Supreme Court has made the above observation as the court felt that the family court in the said case had conducted the proceeding without being alive to the object and reason and the spirit of section 125 of the Civil Procedure Code. Now, 125 of the Civil Procedure Code deals with providing maintenance, providing means to the wife. Okay, now suppose a man is married. Now, it is the responsibility of the husband, the man, to provide means to maintain his wife and the minor child. That is what the Supreme Court has said. Now, the Supreme Court says that such an impression has also been gathered by this court in the case in hand. In this particular case, the Supreme Court feels that the lower court, the family court, has failed to understand the real purport and meaning of section 125, which deals with providing maintenance, providing means to the wife, right? Now, during divorce proceeding, in a divorce proceeding, the wife can legitimately ask for certain maintenance in case she is not working. So, if a woman is not working, does not have his own way of income, it is the duty of the husband to provide means in that sense. So the Supreme Court said that the lower court, the family court, has failed to understand the real purport, the purpose of section 125. The Supreme Court says that section 125 of the CRPC is a measure of social justice. So CRPC section 125, Criminal Procedure Code section 125, deals with providing social justice to the wife to protect the woman and the children. Furthermore, the Supreme Court has said that it also falls within the constitutional ambit of 15(3), reinforced by Article 39 of the Indian Constitution. I will read each and every provision for your benefit. Section 125 of CRPC, order of maintenance of wife, children and parent. If any person having sufficient means neglect or refuses to maintain the wife, unable to maintain himself, his legitimate or illegitimate minor child, whether married or not, unable to maintain itself, his legitimate or illegitimate child who has attained majority, where such a child is by reason of any physical or mental abnormality or injury unable to maintain himself or herself. So, if a husband, if the father has means of money, he cannot neglect his wife, his children or his parent. That is the key provision under section 125 of the Code of Criminal Procedure. I hope that you guys are understanding this, right? I hope you guys are understanding, right? Okay. Okay. Is that clear, everyone? Every one of you? Is that clear? Okay. Brilliant, brilliant, brilliant. Let's move on. Now, apart from this, the Supreme Court in this particular judgment is very aware of the fact that the father has a responsibility to maintain the wife and the children. Now, BYJU'S exam prep, before we move ahead, BYJU'S exam prep brings to you BYJU'S exam prep test series. Now, in the test series, we are providing you 45 plus mocks, unlimited access to 20 CLAT and 25 non-CLAT mock tests, 9,000 plus practice question, topic, test covering every single subtopic, 3 all India mocks with video solutions, detailed mock analysis, test series which are created by NLU alumni based on actual exam pattern. So if you join the test series, okay, we call it the test series, yeah. If you guys get this test series, you will get 20 CLAT mocks and 25 non-CLAT mocks. For example, there will be certain mocks relating to ALIT, Maharashtra CET, SLAT, Symbiosis. Is that clear? So do get this BYJU'S exam prep test series today itself. Moving on. So it is the duty of the father to maintain the father or mother who is unable to maintain himself or herself. So a magistrate of the first class may, upon proof of such neglect, order such person to make a monthly allowance for the maintenance of his wife, child, father or mother at such monthly rate not exceeding 500 rupees in the whole, as such magistrate thinks fit, and to pay the same to such person as the magistrate may from time to time direct. So the magistrate has the power to direct the husband in case it feels that the wife, the child, the mother or the father is neglected, does not have sufficient money to provide himself the maintenance. The magistrate can direct. The magistrate can direct the person concerned to make certain payments. So that is very, very important provision. Now, the provision also says that it deals with minors. Very, very important, okay? I would just highlight those things for your benefit. Minors means people who are below the age of 18. Wife, a woman who has been divorced or has obtained a divorce. Her husband who has not remarried. So a wife includes a woman. Now, such allowance shall be payable from the date of the order. Okay? Now, if any person so ordered fails without sufficient cause to comply with the order, then the magistrate may, for every breach, issue warrant for levying the amount due in the manner provided. So, if the person disobeys the order, the magistrate can issue warrant. He can be arrested for that purpose. Is that clear? Am I clear to each and every one of you? Am I clear, everyone? Okay. Charu, yes, it is very possible to crack ALET provided you do a lot of hard work. Now, hard work is really, really important. Now, if you do your hard work, then I'm definitely sure that yes, you will definitely get through. Okay, don't worry. Okay, my best wishes are always with you. Okay, moving on. Now, provided that no warrant shall be issued for the recovery of any amount due under this section unless an application is made to the court. So, if the court, if an application is made by the wife or by the minor child or the father or mother that the amount of money that was required to be paid has not been paid, then the court will make certain orders. Without an application, the court will not pass any order. Is that clear? Is that clear? So that is all about it. Please, I'm sure that the entire section has been quoted for your better understanding. Explanation is very important. If a husband has contracted marriage with another woman or keeps a mistress, it shall be considered to be just ground for the wife refusal to live with him. Now, this is very, very important. Now, if a husband has a mistress or has contracted with a marriage with another woman, the wife can refuse to live with the husband. Okay, that's very normal. No wife shall not be entitled to allowance from her husband under this section if she lives in adultery. So if she has some adulterous relation with some stranger, then the wife cannot be entitled for this allowance. On proof that any wife in whose favor an order has been made under this section is living in adultery, or that without sufficient reason she refuses to live with her husband, or that they are living separately by mutual consent, the magistrate can cancel that order. So this is just for your understanding. So guys, another reminder for you, BYJU'S exam prep brings to you the test series, right? Enroll yourself today itself. You will get unlimited access to 20 CLAT mocks and 25 plus non-CLAT mocks. Now, Article 15, subclause 3. The state can make special provision for women and children. So, Section 125 CRPC has its roots in the constitutional provision of 15 subclause 3, which says that the state can make special provision for women and children. Is that clear? Now, Article 39 has also been talked about. This deals with directive principles of state policy. The state in particular can direct its policy towards securing citizen, men, women equally have the right to adequate means of livelihood, ownership and control of material resources of the community are to be distributed to subserve the common good, and that the operation of the economic system does not result in concentration of wealth, equal pay for equal work, health and strength of the workers must be protected. It is a duty of the state. So, based on these constitutional aspects which are mentioned, you have 125 CRPC. Okay. Children are given opportunity and facility to develop in a healthy manner and in condition of freedom, dignity, and that childhood and youth are protected against exploitation. Is that clear? So, to protect child, youth from exploitation, certain laws can be made by the state. Okay, let's move on. The next important judgment, Madan Mohan Rao versus Bhim Rao Patil. Litigant can't be expected to wait indefinitely for reasons. Now, I'm sure that you must be aware of it. Okay. Now, this is very, very important. Bail petitions are pending in the courts for years after years, and the Supreme Court is not happy with it. Now, suppose a man is arrested for a particular allegation and he moves a bail application before the court. His liberty is under threat. He does not have the liberty like you and me to move around the city. He is put inside the jail and he is asking for a bail. Now, petitions after petitions are pending in the court for years after years. There is no hearing at all. The Supreme Court came down very heavily in this case. The position obtaining at present is that even after more than 3 months after the pronouncement of the order of the High Court, the reasons are not forthcoming and not made available to the parties. Now, in a judgment, reason is the backbone of the judgment, right? A judgment without reason is void, is null and void. So, there are certain cases in which high courts have passed orders, has passed judgments. For example, the High Court says, Mr. A is entitled for A, B, C, D things. But why has the High Court come to this conclusion? They have not said. So it is the duty of courts to give reasoned judgment. Reasoned judgment, right? It is important that a reasoned judgment is given by the courts. Now, over here, what we see is that an order has come, but there is no reason why that judge has come to a particular conclusion. The judge can come to a particular conclusion or a big particular conclusion. Fair thought. But the judge has to give reasons. Now, we have seen years after years that high courts especially have passed orders without giving reasons. That is very wrong. So the Supreme Court came down very heavily on it. Looking at the nature of litigation and the overall circumstances, we find it difficult to countenance this position. We are of the view that the guidelines and observation therein made remain fundamental to the course of dispensation of justice, and in cause before the court, and the principles set out therein needs to be applied with necessary variation as may be necessary in a given case. So the Supreme Court over here says that it is the duty, it is the fundamental duty of judges to provide reason, or else the dispensation of justice, the dispensation of justice will not be subserved. Is that clear? The dispensation, there will be an obstruction in the administration of justice if orders are just coming out from the court without any reason. The Supreme Court has said that even after more than 3 months from pronouncement of the orders of the High Court, the reasons are not forthcoming. They are not available, either of the parties. So either of the parties are not aware why did the court come to a particular conclusion. Now, unless and until the reasons are given, you cannot challenge that order in the higher authority. Now, High Court orders are not final. They are subjected to overruling by the Supreme Court because Supreme Court is a higher authority. So it is the duty of the High Court to provide reasoned order in every case, or else parties cannot avail their legal rights insofar as challenging that order is concerned. Parties to a litigation cannot be expected to wait indefinitely for availability of the reason for the order of the court. Am I clear to each and every one? Are you guys able to understand? Sir, I'm in class 12. Can I give the CLAT exam which will be held in December? Absolutely, Dinesh Tiwari. Okay. Is that clear? Is that clear to each and every one of you? Okay. Now, the Supreme Court referred to this very famous case of Anil Rai versus State of Bihar and other cases wherein the Supreme Court had laid down certain guidelines and observation relating to fundamentals to the course of dispensation of justice. Principles set out therein needs to be applied with necessary variation. So that means the Supreme Court says that it is absolutely important for the court to pass reasoned order. Just the order is there. There is no reason. It is not done. The Supreme Court has come down very heavily. Okay. Before moving on to the next judgment, BYJU'S exam prep brings to you BYJU'S exam test series. 45 mocks, 20 CLAT, 25 non-CLAT, 9,000 practice question, 3 all India open mock, detailed mock analysis, and which is based on, and this mock test is based on the actual CLAT examination. So why wait? Get your test series subscription today itself. Moving on. The Supreme Court in Jagdish Sani versus State of Rajasthan held that leave encashment benefit is part of the salary. So the Chief Justice of India, bench headed by the Chief Justice of India, Justice Lalit, has said that. Now, what is leave encashment? Now, suppose suppose you are working in a company and your company says, you have 20 leaves in a year. 20 leaves. You can take 20 leaves in a year. The company also says that if you do not take those leaves, we are going to pay above your salary for those 20 days. So you can take those leaves. You don't get the money. If you don't take those leaves, you get money for those days. The Supreme Court has very categorically said that leave encashment is a part of a person's salary. Now, it can be carry forwarded, privilege leaves and other leaves, sick leaves. There are various types of leaves, right? Personal leaves and all. So these leaves which can be carry forwarded, okay? And at the time when you leave the organization, you can encash the money insofar as those leaves that you were entitled to but you have not taken. Supreme Court says the entire leave encashment that you get is a part of your salary. In the present case, the appellant had to fight for their entitlements. The state initially refused to give them the benefit of regularization. So far as leave encashment dues are concerned, this is very, very important. The issue is no longer at large. In senior secondary school, this court held that salary under the act includes leave encashment. So there was a direct judgment of the court which said that salary includes leave encashment. I hope you understood this concept of leave encashment, okay? I hope that you understand this concept of leave encashment. Leave encashment simply refers to the fact that a person who is working in a particular company has certain leaves, okay? He is entitled to certain leaves. If he does not take those leaves, then he is entitled for the money in lieu of those leaves. Am I clear? Every one of you? Okay, brilliant, brilliant. The Supreme Court said that in Pani Ram versus Union of India, it was, and in other Inland Water Transport Corporation versus Brojonath Ganguly, it was held that right to equality guaranteed under Article 14 of the Constitution would also apply to a man who has no chance, or rather no meaningful choice, but to give his assent to a contract or to sign the dotted lines as in prescribed in the standard form. However, unfair, unreasonable, and unconscionable a clause is the contract in its form rule may be. The Supreme Court says that the state, now Article 14 is of great consequence over here. Now, every person has a right to equality, equal protection of the laws as well as equality before the law. So there is two concepts in under Article 14, equality before the law and equal protection of the laws within the territory. That means that the state shall not discriminate a person on the ground of religion, race, caste, sex, and place of birth. Now over here, there is no violation of Article 14. There is no violation. That is what the Supreme Court has observed in this particular case. Okay. Now moving on to the next important judgment, and this is perhaps the most important judgment. A 5-judge constitution bench, which was headed by Justice D.Y. Chandrachud, held that it is up to the Election Commission to decide who is the real Shiv Sena. Now, I'm sure that you must be aware of the Shiv Sena dispute between the Eknath Shinde camp and the Uddhav Thackeray camp. So, Shiv Sena was one party under Balasaheb Thackeray. After he died, Uddhav Thackeray became the head, and he had a government with the Congress and the NCP in Maharashtra. Now, I'm sure that you must have read in articles that certain group of Shiv Sena MLAs went to Guwahati, they were in some hotel there, they went to Gujarat, whatever that fiasco was. Now, the Supreme Court has said that the Election Commission is the constitutional authority under the law to decide who is the real Shiv Sena. Now, Uddhav Thackeray today has less MLAs than the Eknath Shinde group. Now, Eknath Shinde happens to be the Chief Minister of Maharashtra. He belongs to the Shiv Sena. He claims that it is his party, that the Eknath Shinde camp, which is the real Shiv Sena. Uddhav Thackeray says that I am the real Shiv Sena. Now, who is the real Shiv Sena? The party has to be decided. Now, who is going to decide it? Now, under the constitutional scheme, it is the Election Commission who is going to decide who is the real Shiv Sena. That is what the Supreme Court has said. So the Constitution bench dismissed the application that was filed by Uddhav Thackeray group, that claiming that the Uddhav Thackeray group is the real Shiv Sena. Supreme Court says we are not deciding who is the real Shiv Sena. Let the election commission, who has the constitutional authority to decide, let them decide. So the Supreme Court says that we direct that there would be no stay of the proceeding before the Election Commission of India. The political parties in as much wider configuration than the legislative unit of the party, which consists of the elected members, does not dispute in relation to the former's legislative unit. So this is a little technical. So this was the matter. Okay, this was the issue at hand, wherein a constitution bench headed by Justice D.Y. Chandrachud, there were other judges also, okay, who decided on this particular issue after hearing both the sides in this particular case. Okay, I hope you understood this. Any doubts? Any doubts? Any doubts, guys? Any doubts? Any doubts? So these important judgments are going to help you in a great way, because you get to know the legal developments, and once you get to know the legal developments, it is more than enough insofar as your preparation for this CLAT 2023 is concerned. Okay, is that clear? Am I clear, everyone? Is that clear, every one of you? Okay, brilliant. So BYJU'S exam prep brings to you BYJU'S exam prep test series, which includes 45 mocks, unlimited access to 20 CLAT and 25 non-CLAT mocks, 9,000 practice question, topic test covering every single subtopic, 3 all India mega mocks, video solutions by various CLAT experts, detailed mock analysis, test series which are curated by NLU alumni, and these mock tests are based on the actual exam pattern. So do not miss it. Now, BYJU'S exam prep also brings to you a CLAT 2023 crash course, a must-attend series to cover CLAT 2023 syllabus starting from 2nd of October on our YouTube channel. So we bring to you a crash course. Subscribe to this YouTube channel, guys. Now, if you like this session, do press on the like button. And I expect each and every one of you to attend the crash course, which is starting from the 2nd of October, every Monday, Wednesday, Friday, and Sunday at 9 p.m. Okay? So guys, do subscribe and press the bell icon in our YouTube channel. Do follow us in our Instagram page. Do like our Facebook page. Do join the Telegram channel. And definitely do not forget to download the BYJU'S exam prep app. So guys, with this, we come to the end of this session. Thank you very, very much. Have a great day ahead. Have a great Navratri ahead. Bye-bye. Take care. See you soon.